system, and we're talking to the district judge for the Middle Tennessee District, Judge William J. Haynes. And of course, Judge Haynes, before we had our first commercial break, we indicated that we wanted you to talk about some additional things in reference to being a district judge in a real sense, and some of the things that many people might not be familiar with, and so that we can use this primarily as a teaching tool, and that's what we are concerned about this morning. Let's talk about judicial appointments. I think that all of us are familiar with these appointments being made by the president or somebody else, and et cetera, and we really don't understand the steps that are involved in it. So why don't you just sort of take us through some of the judicial appointments that you think that we ought to be familiar with, some of the efforts in terms of making a judicial appointment.
Well, judicial appointments under the Constitution is reserved, is really an interreaction between the executive branch and the legislative branch. The Founding Fathers determined that for this branch of government that they would have an interdependence of political power. That is expressed in that the president has the authority under the Constitution to nominate judges for lifetime tenure, because with lifetime tenure it is a significant appointment. However, the Founding Fathers concluded that the United States Senate would have the authority to confirm nominees, to give advice and consent on whether this person should have a lifetime tenure. Because once you are vested in that office, you have life tenure, and you have the authority to, in fact, affect people's lives. And so the process involves a dual exercise of authority under the Constitution. As a practical